Hello everybody. Today we are discussing a very important subject. This is a recent USCIS policy that caused concerns for many people across the country, students, workers, even immigration attorneys. The memo concerns I-485 applications, commonly known as adjustment of status applications. This is when you come to the US on a temporary visa and you would like to file for a green card to adjust status in the United States. This is when you come to the country with a temporary visa and you file for a green card without leaving the country. The recent memo states that adjustment of status is discretionary and it's an extraordinary relief rather than a substitute for immigrant visa processing outside of the US. This is a major development, but before going forward, I want to make one thing clear. The law itself hasn't changed overnight. Congress has not amended Section 245. Adjustment of status still exists in the statute. What changed is the USCIS interpretation of Immigration and Nationality Act Section 245. What has changed is USCIS's announced approach to how officers should exercise discretion in adjustment cases. The timing is also important. USCIS announced this on a Friday night before the long weekend. This raised eyebrows. It is almost like they come up with something and they don't have to give an explanation for 3 days and see how people react to this. When USCIS announces something on a Friday night before the long weekend, it usually means that they even don't know how to apply this. At minimum, this rollout tells us that there are a lot of questions unanswered. In this video, I'll try to cover 4 topics. First, what the memo says. Second, who may be affected. Third, what the legal concerns are, what we expect in the near future, how you should move ahead if you have a 485 application pending or you're gonna file one. Let's start with what the memo says. This memo says 485 is not automatic, it's based on discretion, and the memo use the word grace. So it's a grace provided by USCIS if you are filing a 485, whether to grant it or not. It is true that adjustment of status has always involved discretion. INA Section 245 uses that language actually. USCIS officers always had the authority to determine whether an applicant is legally eligible and whether applicant deserves it as a matter of discretion. What is new is the tone, intensity, framing of this memo. USCIS is now emphasizing that adjustment of status is an extraordinary form of relief which allows applicants to avoid immigrant visa processing at the consular posts. What USCIS further states is adjustment of status is not a procedure designed to supersede the regular consular visa processing system. This is why people are concerned, because for decades, adjustment of status has been used as a path for green card for eligible applicants within the US. Many family-based applications, employment-based applications, H-1B workers, L-1 managers, F-1 students, parolees, and others have relied on the 485 process. So while USCIS is presenting this as a reaffirmation of the existing law, the practical effect is way more restrictive. The agency appears to be telling its own officers, do not treat adjustment of status as a routine application. Do not approve merely because people check boxes and they seem eligible. Look at the totality of the circumstances. Weigh positive and negative factors. Decide whether this person truly warrants favorable exercise of discretion. That may sound a little technical, but in real life this has a lot of implications. It could mean more scrutiny, more requests for evidence, more interviews, more notices of intent to deny, and eventually maybe more denials. Who may be affected? This memo potentially affects everybody who's going to file a 485 application within the US. That includes several major categories. First, employment-based applicants. EB1, EB2, EB3, national interest waiver, PERM, multinational executives, extraordinary ability, green cards, and national interest waivers. Many of these applicants are already in the US in various non-immigrant visa categories such as H-1B, E1, E2, L1, O1, P1, etc. Second, family-based applicants. This includes spouses of US citizens, green card holders, parents of US citizens, children of US citizens, and other family preference applicants. The impact will probably be the most significant if applicants have any unauthorized stay in the US, unauthorized employment, or criminal charges. Third, students and visitors. F1 students, B1 and B2 visitors, J1 exchange visitors who are coming here and filing green card applications may face more scrutiny because their intent while filing an adjustment of status may be questioned. Fourth, parolees and applicants with prior immigration complications. If you have entered through parole, failed to depart as expected, violated status, worked without authorization, or have criminal or immigration history issues. Fifth, even dual intent visa holders such as H-1B and L-1B visa holders are not completely insulated. This is actually one of the interesting parts of the discussion because for many years H-1B and L-1B visa holders have understood that their visas have dual intent. In other words, they can hold non-immigrant visa status and at the same time apply for adjustment of status within the US. But the recent memo language suggests that just because you're holding an H-1B or an L-1 status does not mean that you can automatically adjust status within the United States. Obviously, this doesn't mean every H-1B or L-1B holder's green card applications will be denied. But it does mean that officers are instructed to look for more than lawful status. They may look for additional positive equities and may weigh the totality of the circumstances while adjudicating the cases aggressively. Let's talk about the practical risks. What are the practical risks? The biggest practical risk is uncertainty. Previously, many applicants believed that if they're in the US legally, if they followed the law, if they did not have any criminal issues, and had an immigrant visa available immediately, they can get the green card within the US. Now the issue becomes even broader. If I do all of those things, follow the law, maintain the status, stay away from criminal activity, am I going to be able to get the green card within the US? Because now adjustment of status is served as a discretion. Because now adjustment of status is described as an extraordinary relief which may be granted by the grace of USCIS. Does your application warrant a favorable discretion by USCIS? This memo may lead to more requests for evidence. It may lead to more interviews, notice of intent to denies, delays, discretionary denials, and case-by-case unpredictability, and that is the worst. For applicants with clean records, continuous lawful status, strong family ties, strong employment history, and no adverse factors, the risk may be more manageable. But applicants with adverse factors may need a much stronger legal representation. Adverse factors could include prior overstays, unauthorized employment, gaps in lawful status, inconsistent statements to consulate officers and USCIS officers, criminal history, even though the issue itself may not prevent you from getting the green card, prior misrepresentation concerns, weak evidence of compliance with the original visa purpose, or other facts suggesting that even though the person entered with a temporary visa, the intent was more permanent in nature. I think another risk is the possible defensive mindset of the immigration officer. Instead of asking, do the totality of the circumstances test allow me to approve this case, some officers may feel pushed toward asking, why should I take the risk of approving this case and losing my job? That shift matters because discretion must be exercised individually, rationally, and fairly. That's why discretion is there in USCIS's books. It should not become a presumption against adjustment of status, and this is actually what this memo is trying to do. There's also an important concern about internal pressure on USCIS officers. If an officer receives a strong message that adjustment of status is extraordinary, disfavored, or politically sensitive, the officer may hesitate to approve cases, even where the applicant is eligible and has no serious adverse factors. This is why this memo is just not a legal document. It is also an operational signal. Do not file your green card applications within the US. That is what this administration wants. And here's the problematic part. Even if this memo is later withdrawn, limited, clarified, or blocked by a court, it may still influence how officers think about the cases right now. It can also influence the applicants who will file these applications, because sometimes clarifying a memo, challenging it at the court, takes a long time, and during this time people have already made their minds not to apply. And this is a serious concern. I just want to analyze the memo on the legal side a little bit and see what kind of interpretation it brings to the game. I think the major point is adjustment of status is discretionary, but it has not been treated as an extraordinary or rare relief within the US immigration system. Section 245 uses the word may, but USCIS now interprets it as extraordinary relief. But may does not mean extraordinary. I think everybody agrees that if there are adverse factors, USCIS must use its discretion to approve the case. But when there are no significant adverse factors, adjustment of status is generally expected to be approved by USCIS. Approved and granted as a matter of discretion by USCIS. That is an important distinction because discretion does not mean USCIS can transform a long-established process into a nearly unavailable exception. Because Immigration and Nationality Act Section 245 clearly authorizes adjustment of status. The criticism here is that USCIS is taking the word may in the statute and turning it into a much higher standard only in extraordinary circumstances. That is legally significant because Congress created adjustment of status as a statutory process. It did not describe it as a rare exception available only in extraordinary circumstances. That is what this memo is trying to do. So the legal argument here is that USCIS is trying to impose a standard that Congress did not intend to create. And that, my friends, require lawmaking. There's also the Administrative Procedure Act. If USCIS is effectively changing a substantive standard in the procedure, the agency may have needed a notice and comment rulemaking. That's where you explain to the people what you're going to change in the near future. You let the people comment about that rulemaking and you give people time for this to become effective. USCIS did not do that. USCIS is trying to do that. USCIS is trying to change the law here with just a memo to its own officers. So USCIS appears to present the memo as a guidance to its officers. But if the memo changes a binding rule that changes the outcome for the applicants, that may become a central issue in litigation. So in other words, the issue is this merely an internal guidance, or is it a substantial rule change that changes the rights and expectations of the people? If it's the second, then the courts will look at this very carefully and see whether USCIS followed the legal procedure. There's also a practical point where USCIS's guidance is a little off. This comes in the employment-based applications adjustment portability rule. Congress allows certain employment-based adjustment applicants, after the I-485 has been pending for more than 180 days, to port to a same or similar job. This is actually how many applicants stay in the United States after losing their jobs with their current employer, and the law specifically allows it. So if USCIS is telling you, no, you cannot adjust, you have to go back and get the green card from your own country, that actually conflicts with Congress's intent to keep these employees here. The other issue is the dual intent. As you know, H-1B and L-1 visas are dual intent visas. You may be staying temporarily in the US, but you may be pursuing permanent residence at the same time. So this memo recognizes that there are dual intent visas, but at the same time it says, just because you're maintaining your H-1B or L-1 visa, does not mean you can adjust status within the US. This creates uncertainty for highly skilled workers working in H-1B and L-1 statuses. And it does not seem to be what the Congress has intended to do for these dual intent visas. How about the pending cases? This memo says it's effective immediately, but it doesn't say anything about what's going to happen with the pending already filed cases. This may be one of the most troubling issues because people filed their 485 applications without the existence of this memo, and some of them were filed years ago. And now they face a different adjudicatory environment. Also, USCIS released this announcement on a late Friday before a long weekend. I don't think this is just a public relations detail. It matters because major immigration policy changes require clarity. Applicants, employers, families, attorneys need to know what the law is. Instead, USCIS releases a memo that raises more questions than answers. That may suggest one of the two things. Either USCIS has not developed the practical implementation framework, or USCIS intentionally wants to see public, legal, and political reaction before clarifying how aggressive it wants to be. Either way, the result is uncertainty. And uncertainty is damaging immigration law because people are trying to live a life here. They're going to have to make these life-changing decisions based on uncertainty in the memorandum. Whether to file an application, whether to travel, whether to change jobs, whether to marry, whether to accept employment, whether to remain in the US, whether to pursue a visa, or whether to pursue consular processing abroad. So let's move on to what should the applicants do now part. At this stage, applicants should not make any rushed decisions. Do not withdraw your 485 without legal advice. Do not leave the United States without understanding what the advance parole is, visa stamping risks, unlawful presence issues, inadmissibility risks, and whether departure could create a separate problem. Do not assume that consular processing is automatically safer. Consular processing may be advisable in some cases, but it can also involve serious risks, including delay, administrative processing, inadmissibility findings, separation from family, interruption of employment, and difficulty returning to the US. The most important step is to review the cases individually. For pending I-485 cases, it may be wise to wait and see how USCIS will interpret this policy in the upcoming interviews. You may gather evidence starting from now. This may include tax records, employment verification letters, proof of lawful status, proof of compliance with visa terms, community ties, family evidence, hardship documentation if you were to leave the US, evidence of good moral and character, evidence of professional achievements, and legal arguments explaining why a favorable discretion is warranted. However, it is also important to note that USCIS does not always apply these memos as hard as they sound. Sometimes they just release something and see the reaction and then clarify the memo in the upcoming days, weeks, months, or they don't, and we just see the interpretation of it during the interviews. So what we, immigration attorneys, will experience in the upcoming adjustment of status interviews, I think is going to be very important. I would probably advise to wait and not change anything major and see how this policy will roll out and how the implications and interpretations will be by USCIS officers. We will have a better idea in the upcoming weeks, months about the application of this memorandum. So what to expect in the near future? First, we expect legal challenges. This memo raises serious legal concerns, both statutory and administrative law, including whether USCIS is interpreting the statute right and whether the agency went ahead and created substantive policy change without the proper procedure. Second, we expect more USCIS guidance. The current memo leaves many questions unanswered and it creates uncertainty rather than certainty, as has been usual with this administration. What counts as extraordinary circumstances? How will pending cases be treated? Which applicants are at most risk? Will there be exceptions for national interest, healthcare workers, STEM professionals, spouses of US citizens, children of US citizens, or vulnerable applicants? How about asylum seekers? If you are granted asylum, you cannot go back to your country. And the other memo says you can only get your green card from your own country. Are these people going to be able to adjust in the United States? Will officers receive detailed instructions? Will there be a checklist? Will there be a presumption against adjustment? Those answers and many more are not yet clear. Third, we expect either a stall in adjustment of status adjudications or inconsistent implementation at first. One way to handle this is pause all the 485 application decisions and see how they're going to react to it after all the supervisors and officers understand what the memo actually means. And I think this is what's going to happen. But if they don't do that, then different agencies, then different officers and different supervisors may understand different things from this memo, and there may be inconsistent decisions across the board. Think about the same scenario where California field office gives a different decision than the New York field office, for example. Because different officers and different field offices may apply the memo differently until USCIS provides more detailed instructions or litigation clarifies the rules. Fourth, we expect more scrutiny in the I-485 applications. Even if courts eventually limit the memo, the applicants should be prepared for officers to ask more questions about immigration history, intent, status maintenance, unauthorized employment, travel history, prior visa denials, prior visa applications, and why adjustment should be granted as a matter of discretion. Fifth, we expect the strategy to become more individualized. Old assumption that adjustment is really perfect for everyone inside the United States may no longer be safe. But the opposite assumption is also dangerous. Consular processing is not automatically better for everyone. The right strategy depends on the case and person's immigration history. Sixth, we expect USCIS to watch the reaction closely. Because I think the reason this memo was announced on a Friday before the long weekend is because USCIS is looking at the reactions of the applicants, of the attorneys, of the employers, of the trade associations, advocacy groups, courts, public response, and also congressmen, congresswomen, and senators. It is very wise at this point to reach out to your congresspeople, your senators, and let your voice be known that this is unacceptable. If the backlash is significant, USCIS may issue clarification, FAQ, additional internal guidance, and revised language. There's also instances where USCIS withdraws a memo, although I don't think that's going to happen with this administration until they are challenged in court. If litigation is filed quickly, which I think it will be, the agency may be forced to defend whether this memo is merely a guidance or it is actually a substantive rule that should have gone through notice and comment procedures. So the next several weeks are very important. The memo itself is only the first step and we don't know everything, and I don't think they know everything. We will just see how this is interpreted in time. The real impact will depend on how officers will interpret it, how USCIS clarifies it, how quickly lawsuits are filed, and how courts respond. So in closing, the bottom line is this. This memo is serious, but it is not the end of the adjustment of status. It's just the beginning of a new era where we have to see how this memo will be interpreted. Adjustment of status remains as part of the statute. USCIS cannot erase statutory processes simply by memorandum of law. But USCIS can create uncertainty, and that is certainly what they did. USCIS can pressure adjudicators. USCIS can make officers more hesitant to approve the cases. And USCIS can make procedures more difficult, more discretionary, and more unpredictable unless courts intervene, unless there is a public backlash, and unless the agency clarifies its position or the policy is challenged successfully. The timing of the announcement, late Friday, before a long weekend, only adds to the concern. It suggests that USCIS may not have fully developed the practical framework for this policy and may be watching legal and public reaction before deciding on how aggressively to interpret it. For applicants, the best response is not to panic. The best response is preparation. Do not assume your case will be denied. Do not assume you must leave the United States. Do not withdraw a pending 485 without legal advice. But also do not ignore the memo. Follow the development. documents, because every case is different. If you have a pending adjustment of status case, or if you're preparing to file one, this is the time to review your immigration history carefully and decide on what to do, because every case is different. A clean employment case, a marriage-based case with an overstay, a parole-based case, an F1 student case, and an H1B portability case may all require different strategies. We will continue monitoring this memo, legal challenges, USCIS implementation, and any additional guidance. As soon as there are meaningful new developments, we will share them. If you don't know, my name is Ramsey Kulen. I've been practicing immigration law for more than 20 years. I've helped thousands of families and businesses achieve their immigration goals. Please subscribe for more updates and contact Kulen Law if you need case-specific information. I'll see you in the next video. Take care.